Hi, my name is Alison McCarthy, and I am a victim services specialist in our Victim Rights Legal Services program. I'm here today to talk to you a little bit about victim impact statements. So what I'll do is I'll share some basics, and then I'll share some suggestions and tips around crafting a victim impact statements, and then I will talk a little bit about some logistics around that. So to start with some basics. The first thing I want to share is that your right to read a victim impact statement or give one at sentencing is protected under the Victim Rights Act. So you have the right to be heard at sentencing, and a lot of times the way that that plays out is by victims sharing their statements. That said, you don't have to submit a victim impact statement if you don't want to. No one is going to make you. If you do want to submit one, you can do so in writing, which can be ahead of time, or at the moment of sentencing, or it can be orally at the sentencing hearing. The DA's office may share the victim impact statement paperwork with you early on in the process, and they may give you a deadline for when that statement needs to be turned in. The thing to know is that anything turned in ahead of sentencing will be shared with the defense and the judge. So the deadline that you're given is what the DA prefers, but technically you can keep working on your victim impact statement right up until you read it. So, and even with that, it's not required that your statement be written. It can be an emotional experience to deliver a statement like that, so it can be helpful to have at least an outline written, but it is not required. Some tips or suggestions as you craft your victim impact statement. While the paperwork that you get from the DA's office will provide some prompts, you don't have to follow them if you don't want to. For the first few drafts, my suggestion would be to not censor yourself. So you can do something like set a timer if you want, or turn off your computer screen as you type, and then just get it out. Say everything that you want to say. Don't worry about spelling, grammar, or making something court appropriate. It's totally fine to swear and go on tangents and whatever else might come to mind for those first few drafts. Then, as you have that down, you can start to identify the pieces that feel most important and to include in your statement, and go ahead and start working on polishing those. And you don't even have to do it by writing at first. Some people prefer to do it by doing like voice memos or by taking notes somewhere as they come up with things that they want to say. So whatever process works for you, that's what you should go with. And the whole point of a victim impact statement is to voice what impact the crime has had on you. So as I mentioned, this is both the actions of the defendant and the court process itself. So if it's been a grueling, anxiety-producing type of process, it's okay to name this here. It's also a good time to express any desires that you might have around the sentence itself. So sometimes crimes have what's called a presumptive range. So that's a presumptive prison sentence range of, let's say, 4 to 8 years. Unless it's specified in a plea deal, it's often up to the judge to decide the length of the sentence. It's completely appropriate to tell the judge what you'd like to see happen. I will say one thing to keep in mind here is that typically defendants will serve half of their prison sentence. So just something to remember as you express what you'd like to see happen. In addition, if the defendant took someone's life or significantly altered someone's life besides your own, you can speak to that loss by telling the court about that person, what they were like, what the world has missed out on because this person is no longer here or no longer the person they were before the crime, or things like that. Few logistics to wrap us up here. I would recommend keeping your statement to no longer than 5 minutes or so. Most judges are understanding and will not cut off a victim who's speaking if they go over that time limit, but just in case. One rule is that you cannot address the defendant directly. Your statement should address the court, which means the judge. Sometimes judges will allow a loophole of something like, if I could tell the defendant something, I would want to say blah, blah, blah. But there's always a chance that the defense attorney will object and or that the judge will interrupt and redirect. So just know that. While in those early drafts, I was saying it was totally fine to swear and all that, when you're actually giving your statement, courtroom decorum is expected. So avoid swearing or any derogatory comments towards the defendant or things like that. It's also not uncommon for people to feel lots of anxiety and or get emotional as they read their statement. A support person, an advocate, or even the district attorney can read the statement for you if you'd like. And this can be something you've decided beforehand. It can also happen in the moment as you're giving your statement. If you decide you do not want to or cannot continue, you can ask someone to finish it for you. Really, what I want to leave you with is that a victim impact statement is for you. It's an opportunity to have your voice heard in a process that may have made you feel excluded or silenced or things like that. So it can be cathartic and healing to write, even if you don't end up sharing it. If all it does is stress you out, though, there's no pressure at all to have one. Please make the choice that is best for you. And if you have any questions or would like additional guidance around writing a victim impact statement, please feel free to reach out to us. Thank you.